Okay, good evening, everyone. And the first thing I want to do is express my appreciation for how you have all approached this course. And I want to commend you for your effort. I felt that when we began the modules on student rights, things started to click for you. And what I've noticed, having taught this a number of years, is that tends to be the way it is. I don't know if it's because the faculty rights are a little less known, and or just the time of that going on. I have a couple of things I want to stress again with you. Is I want to remind you that in real situations, you should never go it alone, meaning that you should ask for help, especially if you're a little bit unsure of what, especially if you're unsure of what to do. And when you do that, understand that as an assistant principal, you have a principal to go to. As a principal, you might have a superintendent or a supervisor to go to. As a superintendent, you have the school's legal counsel to assist you. And for me, for example, when we were in situations where we might be needing to terminate an employee, and I went through that in a couple of situations. Before I started anything, my first call was to the attorney to make sure that I had all my ducks in a row. And he always asked me, don't forget Loudermill. And of course, Loudermill was giving them the right to give provide their information. And in fact, I always we presented that individual. We had that person come in the office, and they were allowed to have representation. And we asked them, he had me show him the paper that I was going to, or the document I was going to give to them, letting them know that we were starting an investigation with regard to the situation that we were investigating. So those are important. As a principal, not only do you have your supervisor that you can turn to, but there's also, in most cases, there's a principal association. There's an elementary association and there's a secondary association. And each of those have legal counsel that you can use. Now, it's not quite as convenient, and you might not get quite as quick of an answer, but at least it's a definite backup. The second one, you heard me say, and I'll stress it again, is you ain't got a problem till you got a problem. Meaning that if you do not, for example, if you didn't provide a student due process properly in a disciplinary situation, or you didn't properly investigate a cyberbullying situation, well, you don't have a problem until you're called on it. Then you might have a problem. So just realize that you want to stay abreast of those kinds of things. So any comments that you folks would have with regard to where we are as far as the course is concerned? Okay, we'll move forward. So please get out your work, and we'll start with the module 13. Appreciate the impact of Every Student Succeeds Act and Common Core on today's curriculum in schools. So who can tell me what the Every Student Succeeds Act is?
Isn't it like where every child deserves to get the same education? And then I know at that point they had the reading level for third grade.
Yes. Okay.
And then if they don't meet that reading level, they would, they can be held back.
Okay. So, it's the federal guidance for K-12 education. And it just covers students in public schools. So it doesn't necessarily address schools in public schools. And it replaced No Child Left Behind. So another thing that I haven't really stressed much to you, but is something I want you to realize, is that with all of these federal laws, or most federal laws, Title IX, for example, every 5 or 6 years, the Congress goes through a reauthorization of that particular bill or that law. They make changes, and you're going to see that play out significantly in special education as we get to that point. So here were the key elements of the ESSA. It created state-centered accountability models instead of federal models. It basically said that Michigan, you decide what your standards are, your accountability standards are going to be, and the same for each state. It allows the states to use federal funds for teacher evaluation. It had not done that before, and states have the flexibility in how and when to administer achievement testing, which was that was the biggest change, because in the previous they were very dictatorial on how those tests had when and how they should be given. And finally, it gave the Department of Education to remain neutral on academic standards. And because of that, that spurred the Common Core. And from what I learned, Michigan adheres to Common Core. Am I correct with that? Carissa?
So yeah, I was gonna get, it does go, oh, sorry.
No, go ahead.
Yeah, it is the Common Core state standards. That's what we go based on.
And, you know, when Common Core first came out, I think about 10 years ago, almost every state adopted it. But then it started to kind of lose some of its appeal. And I don't know exactly how many states use it now. It's good that we have standards. It's good that the attempt was to make it national. Most countries, many countries do have national standards. And so that was all that. Okay, so let's get into the second part here. Consider the aspects of copyright, including fair use with multimedia and Creative Commons on today's educators. Tell me some of the things that you picked up about copyright law.
Copyright law allows educators to utilize copyrighted materials like videos or images and text while we teach.
Absolutely.
And that still allows us to respect their intellectual rights.
Yes. And you know, the bottom line with that is fair use. You can use certain aspects, but the thing you don't want to do is you don't want to use a video, for example, for Christmas assembly. That would not be, it wouldn't be educational. It's not considered educational. It has to be educational. So we're given quite a bit of leeway with regard to the use of copyright material, and particularly in face-to-face world. So what about public domain? What's public domain?
It's works that aren't protected by the intellectual property laws, like a copyright or a trademark or something of that nature. And they're owned by the public, and anyone can use them without citing the original author.
Yes, and so when this becomes important is after, say, 50 years, it loses its copyright, particularly because, you know, the individual who created it is probably passed, and so therefore it becomes public domain. When I mean, typically educators kind of poo-poo copyright. We tend to make copies of whatever it is we want and do whatever we want and think fine and dandy, no big deal. And in general, probably true, but I always like to point out the one case. There's one case called Encyclopedia Britannica Educational Corporation versus Crooks. You're shaking your head, Carissa. What can you tell me? What do you remember about that case?
The court ruled that the defendant's unauthorized recording and distribution did not constitute fair use.
Yes, and it was an educational service center.
Mhm.
And so they were distributing these materials and they tagged them pretty good. I can't remember exactly how, but they tagged them like per use. And I don't know exactly what, can't remember what that was, but obviously it was expensive. So it's just always something to keep in back of your mind. And, I always suggest that principals review copyright law with their teachers at the start of the school year. At least that way they can cover themselves, so to speak. They've made sure that the staff knows that. What's been interesting in the last 10, 15 years has been Creative Commons. And had any of you ever heard of Creative Commons before this lesson? You're not alone. Almost every class when I teach this, they've never heard of it. And it is so cool because what it allows individuals to do, it allows individuals to determine how they want their work to be used or how they will allow their work to be used. So I'll take a little bit of a different posture here for a moment. So I have a book called Technology Ready School Administrator. I used it in my class, and I had every chapter starting with a cartoon that depicted the material that they're going to be digesting in the chapter. And so the first time I wrote it, I was new to all this kind of stuff, and I liked one particular guy's renderings, cartoons. And so I contacted him and I paid, I remember I was quite surprised. I mean, it was only like $25 or $30. Yeah, it wasn't expensive. And he's a big time cartoonist. And so I was thankful and I did that. So when I did the revision, I now knew about Creative Commons. So I started looking for Creative Commons kinds of things that fit the example. And lo and behold, I found items in a couple of instances. Of course, the book was for sale. So I was going to be making some money off of this. And in some instances, they had it non-commercial, they had it marked as non-commercial. So I remember contacting the owner and told him what I was doing, told him I probably wasn't going to sell a ton of copies of this. And they granted me permission, and I kept that all in line. So it's a good idea, and we'd like for you to have an idea of each of these 6 different licenses. The first one is Creative Commons by attribution. Can someone tell me what that is? Well, attribution in and of itself means you have to give that individual credit. So, however, you can reuse it, you can remix it, meaning you can adapt it, you can add changes to it, make it different colors, make it a different medium, different format, as long as you attribute it to the creator. So that is copyright by attribution. The next one, and so many of these, the term itself is pretty descriptive. The next one is Creative Commons by share alike. Can anyone tell me what that is?
I'm looking through my notes here. Is this the one where you have to use it, but in like the same way? I don't
Exactly.
know if you modify it or not when you use it the same way. Okay.
And you're exactly right. You're still allowed to remix it. You're allowed to adapt it, but you have to give attribution. But you also have to share it as it in the same Creative Commons license as it was previous, the share alike part. Okay. So the adaptations must be shared under the same terms. Okay. The next one is very easy. Creative Commons by non-commercial. Non-commercial meaning you can't make you cannot make money off of their work. And as I was telling you about the individual, one of the individuals whose cartoon I used, his was marked non-commercial. Well, I contacted him and told him what I was going to be doing, and he said, okay, that's all right. And of course, I kept his document telling me that. The next one is non-commercial share alike. So putting the two together, obviously non-commercial, but you have to share it the same way that the creator shared it. Credit them and share it the same way. And all of those, you can remix them. You can make changes to them. Now we're into the more restrictive, and that is non-commercial, no derivatives, meaning you cannot make money off of it, and you also can't change it. It has to be done exactly the same way that it was. Okay? So those are basically the Creative Commons licenses. I'll probably have a question on one of those, and it'll probably be one of the easier ones, quite frankly. Okay, so going on to our third objective in this particular group is trace the U.S. Supreme Court cases related to school desegregation in public schools. Can anyone tell me what the very first case was with regard to segregation, basically?
Would the first one be Brown versus Board of Ed?
There's actually a couple before then.
Oh,
But that is a very, very important one.
I don't know, in terms of relation to schools, what we've been covering with my AP Gov class actually today, would Plessy v. Ferguson count in this one? I mean, it's with the separate but equal doctrine.
Exactly. So
Okay.
you talked about it in your class today. Tell them
Yeah.
about Plessy versus Ferguson.
We don't cover it in depth because it's not a required case.
Oh, okay.
But what it establishes, or how we talk about it with the students, is that it has a separate but equal doctrine where so long as there are facilities that offer the same type of thing, like I use the diagram of a trolley car.
Yes.
One trolley car is perfect, has beautiful windows, nice trim, all its wheels. The other one that's attached to it is technically a trolley car, but it might not have any windows. It's all banged up. It's missing wheels. That's the way that I kind of visualize it for the students. So it's technically two trolley cars, very different though in how they look and operate.
So a very good example. So here's the background of this case. Plessy was mostly white. I can't remember. He was like 1/8 black. In other words, there were 8 of his ancestors, and there was 1 black included. During this particular era, 1896, individuals would get on a train, and the blacks would go to the black car, and the whites would go to the white cars. Well, Plessy refused to do that. He got arrested. It went to the U.S. Supreme Court. He lost. He was expected to be in that black car. And so the point you made is the most important part: separate but equal. So these train cars were separate, but they were equal in general. Okay, so that doctrine held for a very, very, very long time, actually until the Brown case, but there's another case in between. And this is Missouri Gaines versus Canada, not the state, but Missouri versus Canada in 1983. Did you come across that one?
That the court held that by establishing Lincoln University as a state university for Black students, that Missouri established precedent for providing equal opportunity in higher education for both Black and white students.
Yes, and in this particular case, he wanted to go to law school. And there wasn't a law school that he could go to that was Black. And so therefore the court said he was allowed to go to that court. So that started to break down the barriers, to say the least. And of course, in studying this era or early days, obviously lots of contentious kinds of things, lots of bad feelings, and I'm happy to think that we're beyond that in general. So then was Brown versus Topeka Board of Education. Carissa, go for it.
All right. State sanctioned segregation of public schools was a violation of the 14th Amendment and was considered to be unconstitutional.
Absolutely. And what a major deal this was in 1954. And so you had Black schools and you had white schools. And typically the Black schools did not have the resources that the white schools had. And so therefore, this became a blockbuster landmark case that said separate is not equal. Therefore, schools must be integrated. And from there, we got into the busing of students, taking students, white students, and moving them an hour away to go to a school that was predominantly Black, taking Black students and moving them into white schools. And it was muddy, I guess, during that era. One of my professors was actually the superintendent of Columbus Public Schools, and he actually administered through that era and told us some interesting stories with regard to that. So there was a court case, Swan versus Charlotte Mecklenburg Board of Education, 1970, and there they upheld busing. So we've come a major long way from those early days, and we gave you some video with regard to today's world. We showed you some 60s. My God, that was a horrible time for the country. Not only the Vietnam War, but you also had the civil rights kinds of protests and the civil rights kind of things going on. It was horrendous, quite frankly. So give me a description of today, desegregation, integration, those kinds of things. Well, I'll give you my take, okay? In today's, according to lots of lots of references, today's world is more desegregated than the past, meaning that you go into the inner cities and you have all Black schools. You go to the rural areas, you have all white schools. But here's the difference. Nobody's complaining. Nobody's complaining. And in the meantime, states have attempted to do a good job of making the resources the same from one school to the next. And for you who've had school financial, remember that we talk about some of those court cases that challenged the funding systems. Well, in most cases, they have attempted to make it so the resources are the same. So in the meantime, I just find it interesting that at this point, everybody is okay with the way it is. And that's where we are. Okay, so now let's turn into special education, which is the most important part of this group of modules. I always like to begin by asking, do we have any special education teachers in here? Not a one, okay. Well. Did I hear somebody say yes?
No, I said no, not me.
Okay.
Yeah.
I always find it interesting because obviously, if you've been trained as a special education teacher, this stuff is pretty commonplace for you. You understand the procedure, you understand the lingo, and the lingo is crazy. I mean, alphabet soup to say the least. Well, I'm going to take you very quickly through the process of how we got to kind of where we are. To start with, in Pennsylvania, of all places, there was a Council for Exceptional Children. And I can't remember exactly the date. I think it was in the 60s. Imagine this, in the 60s, there were children who were just not educated in school because they had challenges. And, that is so heartbreaking for me to think about, that so many children of that era did not have opportunities. Of course, Brown versus Board of Education, not only did it desegregate the schools, it also was talking about equal opportunity. So it was a movement toward equal education, even for those children with disabilities. Then came the Pennsylvania Association of Retarded Children, NICE, versus Pennsylvania, and the Mills versus District of Columbia Board of Education. Both of those cases in Pennsylvania set the stage for special education terminology, processes, and ultimately the federal law. So they were ahead of actually the federal government getting on board with educating children. Then we got into the section 504 of the Rehabilitation Act of 1973, and it pertained to adults and children. And we're going to talk about that in a little bit, the difference between the two of those. And then we get into the beginnings of the federal government getting on board with assuming or making sure that special education handicapped children were provided a fair education. With the Education of All Handicapped Children Act of 1975, and it set the parameters for educational services even today. There was one particular court case that we want to make sure that you are aware of because it has massive ramifications, and that's the Board of Education of Hendrick Hudson Central School District versus Rowley. And in this particular case, Rowley was a hearing impaired youngster, and her parents wanted her to thrive educationally. And so they wanted all of the advances that was they felt afforded or due to her. For example, instruction from a tutor, an FM hearing aid, a speech therapist for 3 hours each week, and they requested a sign language interpreter that was denied by the school district. That started the court case. And through this particular case, it was asking the legal question, do we have to maximize the education of a special education student? Because in the eyes of the school district, when they denied the interpreter, they felt that that was extra and well above. And of course, the U.S. Supreme Court held that public schools are not required by law to provide students with the optimum education. They have to provide a free and appropriate education, but it doesn't have to be optimum. So if a person came and said, my child is handicapped, I want an individual tutor for this child, if the school felt that it was above and beyond, they could deny that. I've done a little bit of research about Dr. Amy June Rowley, the student. She today is the coordinator of the American Sign Language program in modern languages and literature at Cal State East Bay. So she did quite well for herself, and her parents worked very hard to get her to where she is even today. So from there, that particular law became IDEA in 1997. So there is what I'm talking about, where it was reauthorized. In this case, it was renamed, okay? And it's been reauthorized about 2 or 3 times since 1997 with a few changes that took place. I contend that the Columbine incident in 1998, and I'm sure you heard about that situation, I contend that that incident caused changes in IDEA law, because prior to that change that took place, after that, special education students could be expelled from school, and before that they could not. They had to. You could only take a 10-day out of school suspension. So from there, of course, the 2004 changed, and what was added with regard to taking more strict disciplinary action is you had to provide the parents and child with a manifestation hearing, a functional behavior assessment, and an interim alternative educational setting that could be up to a year, the length of the expulsion. And so, in essence, the manifestation hearing basically is asking the question, does this disability, is there misbehavior caused by the disability? Now, I've often argued with parents in suspension hearings that, if your child brings a gun to school and there's special education, I'm sorry, I can't draw the comparison that your disability is what caused you to do that, but you have to go through the process. The ADA, American Disability Act of 2008, clarified the coverages and added assistive technology devices. So you can see, once again, the evolution taking place, okay? The most recently amended IDEA was in December of 2015. It concluded in 2017, so we're going to be due for this again. And with that, the reauthorization aligned the language with the ESSA and removed the definitions to make them consistent with ESSA, removing core academic subjects, highly qualified special education teachers, scientifically based research, some of those kinds of things. Okay. So with that all, that's not all nice and dandy, and it's good to have a little bit of a history behind it. Here are the important things, okay? So can someone tell me one of the basic principles of special education that is included in IDEA? One of the basic, there's about 6 basic principles of special education.
Well, free and appropriate public education, FAPE, would be one.
Absolutely. Free FAPE, free appropriate public education. What this means is that the school is required by law to develop and deliver an individualized program of special education services that meets that student's needs. Has to be free, has to be appropriate. Okay. Another one of those major.
Parent participation,
I'm sorry.
parent participation.
Absolutely. Parents must be involved from the get-go. And that begins when you actually start identifying that a child is having difficulty in school. You should be bringing that parent in and having conversations about that. And it moves all the way through to placement, okay? the replacement.
Least
not?
restrictive environment.
Least restrictive environment, absolutely, Lenise. Can you tell me what that means?
Yes, children with disabilities, or special needs to be, placed in a educational setting, with their peers, with non-disabled peers as well.
Okay, and it has to be least restrictive. So I want you to think about what's called the continuum of services. And the continuum of services goes from the most restrictive, and that is a full-time separate class. So if a child is blind, for example, they might go to a school for the blind. Every state has a special school for blind children. Well, they're separated from their peers, but it's felt that that's the most appropriate for them, going all the way up to the least restrictive, which is regular class without any conditions placed on them. So when you think of deciding the free and appropriate public education, you have to also consider the least restrictive environment. And that's what the team will be deciding, basically. Okay?
An IEP?
Yes, the student will have an individualized education plan, and that will be designed by a cooperative effort. Regular teacher, special education teacher, parent, all should have input into that. I don't know that it works that way. My experience has been that the special education teacher who knows their services better than most writes that plan. It's presented to the parents. Typically, the parents sign off on it, and we go, and then services are provided. Ezra, you have a question? Oh, Angela, I have a question.
Yeah, actually, based on my experience, and this may be different, is I've been told and required by my school that even if I don't attend the IEP meeting, I legally have to provide feedback on the kid.
So I would have to agree with that. So, oftentimes when this group comes together, the regular teacher says, well, the kid's going to be out of my hair, so I don't have to worry about it. Well, the problem is with that is they need to provide information to assist the special education staff to decide what would be appropriate for the child. So yes, I agree that the regular teacher should be in attendance to those meetings. Okay. Other ones of the principles?
Did we cover evaluations yet? Like the idea that it has to be like by an knowledgeable person, and it needs to be like conducted or reconducted if necessary.
Yes, and it's called a multi-factored evaluation, meaning that they're using various pieces of documentation or assessments to determine what the issue is. For example, if the child is severe behavior issue in Ohio, they have to have a doctor has got to examine them. I don't know about Michigan. Probably could be the same, because they want to rule out that it is a physiological issue, that it's more of an academic or a situational issue. And so that doctor might include in that multifactored assessment that there is no, it's not, his issues aren't related to diet, to things such as that. Okay. So one of the ones that's not known too much is called Child Find. And basically, schools have done a great job in locating these children, particularly in this day and age when they're preschools, where children are identified as having challenges. But the Child Find means that the district is required to locate, identify, and provide services to all eligible students with disabilities. Okay. And procedural safeguards, meaning that we've got to comply with procedural due process. We have to go through all those due processes. So that is the principles. very important that you know each of those principles and understand each of those principles. We now get into the process that a school must go through to place a child in special education from suspected disability. And that's what you begin with, suspected disability to placement in a special education program. Angela, have you had an occurrence where you suspected a child with disability?
Many times.
Yes. And so tell me what you do under those circumstances. What steps do you take?
Well, I'll speak to what I did at my old school because I haven't done it as of yet at my new school, even though I have some kids that I suspect.
Okay.
At the old school, what we did is we filled out a form that was sent to basically our special ed department, identifying where we saw the challenges for the student, what our concerns were, and what were the signs that made us concerned that there was a disability.
Okay.
And then they took that form and they came in and observed the kid in our classes. They checked their grades, they watched their behavior, and then from there was a communication with the parents about what they noticed. And then they were encouraged to, if they went this route, they were then encouraged to have their student tested for whatever disability the special education teacher thought might be the cause.
Absolutely. So, do any of you have intervention, response to intervention teams? Have you heard of that terminology?
So with us, we do, well, we used to call it MTSS and now it's SST, where we get together with the team.
Yes.
And we talk about the student, and then as she said, they go observe them. They document, we document, and we try to work with this child before anything. And then, if nothing works, we inform the parents of the concerns. And then they try to get them tested and go from there.
Yes. And so there's been a push for response to intervention, where the regular teacher tries different things before it's automatic, go through the testing and the placement. So tier 1 includes universal instruction and gives the students opportunities to work on their skills. And then it becomes more and more severe. When you get to tier 3, typically it's at that point that we are ready to make a referral for special education services. Okay. And like Angela said, typically there are forms that are filled out, and that referral is then sent to the special education department, and then the system starts to be in place. Okay. And if that suspected disability is thought to be just, then there's a multidisciplinary team that starts to look at the multi-factored evaluation, what we're going to test the child for, and then ultimately grant parental permission from the start. Actually, from the response to intervention, it would be good to have conferences with parents to let them be a part of the process and provide input in what they can do for their child, even though many parents feel that the schools know best to do that. And so at that particular point in time, the questions are asked: does the child have an IDEA disability? Of course, there are certain disabilities that are classified in the federal law. And then, does the child need special education services? And if that's the case, then they appoint the IEP team and ultimately the development of the IEP in itself. Have any of you experienced any other different processes to identify a special education child? Okay, so, once again, the thing that team is looking at with parental input is that continuum of services and deciding which level serves the child best. So I have I have stories. As a superintendent, I attended a number of special education meetings, and I so vividly recall a kindergarten child who was having difficulty, and the teachers wanted the child to go to a separate school, a low functioning separate school. The parent was quite disturbed by this and refused to allow the school to do that. The teachers were very upset, and I basically was the intermediary and basically told the teachers he has the right to decide. I checked with that parent about 5 or 6 years later and asked him how his child was doing. He's doing great. Come to find out, he had eye problems. His issue was his eyes, not necessarily that he couldn't think. And he graduated a regular education and was quite pleased that, because had we placed him in this other service, he would have been very, very limited in his social actions, in his academic abilities, and those kinds of things. So I guess the bottom line is listen carefully to what the parents say, because oftentimes the parents know best, know their child best. So there are 13 different identified categories that a child can be placed in. And the first one, 34% or the most children are classified as specific learning disability, or SLD. Can someone tell me what SLD stands for? Or, I mean, how you're identified as SLD?
Is that speech language disorder?
No. I'd have to say probably kinda, but not. So you could be talking about one of the other disabilities. In this disability, the child is having difficulty reading, writing, speaking, maybe doing math.
Okay.
So it's specific, and they might have dyslexia. They might have auditory processing disorder. They might have nonverbal learning disability. So it covers quite a variety of issues, but it has to do with their lack of ability to read, write, listen, speak. And oftentimes when a student is given specific instruction, they miraculously turn it around. There's been lots of research that's been done with dyslexia. Are any of you aware of some of the research that's been done with dyslexia? So some of the most recent research is they have discovered that if you put a certain color of film over what the child's reading, it corrects it. They don't have the problem. And so there's been lots of research with those kinds of things.
Do you know if it's like something that we can purchase online? Because I have a student in my class that has dyslexia, and I would love to help with that.
Yes. So my suggestion would be talk to your special education staff, see if they could have some resources, or do a little bit of Google researching with regard to that, and see if there's something that could be gotten that way, because they've had lots of success with it. It doesn't work every time, but it does work. And so therefore, the other thing that's interesting with dyslexia, my experience with dyslexia is that when a student, when you point out to a student, look at this, they tend to start to correct that issue. And it is correctable. The thing about it, it is correctable for sure. Although there's some really extreme cases Cher, for example, I guess has dyslexia, very bad. And it, of course, didn't hurt her singing ability, I guess. Okay, so can someone give me another category? I bet you've heard of the autism spectrum disorder. You might even have some students that are autistic. And this covers a wide range of symptoms and pretty hard to track down, quite frankly, but it affects their social and communication skills, and it can impact their behavior. And what we're seeing is that there's been a increase in autistic children. And I contend that some of this has to do, of course, one of the things that we also know is that a student's attention span has gotten shorter and shorter and shorter, primarily because of the society that we live in. And I have a friend who told me that they're autistic, and I mean, they're adults, and they said that when they were going through school, they were autistic. And what I discovered is this person on a basic day will be listening to music on their iPad, trying to read a book, all at the same time. And I suggested, you ought to just focus on one thing. That wasn't part of their desire, though. Okay, you pointed out one, Lenise, and that's the speech or language impairment, speech therapy. And it too is another one that is correctable, stuttering, problem pronouncing words, and processing. Lots of times these are because the way they hear it at home is wrong. And so therefore they think it's correct until they get to school and find out it's not that way. And I when thinking about this, I always think of myself, because as a young person, I had a hard time distinguishing between CH and SH. Those two sounds, I don't know why, can't explain it. I finally corrected it, but I remember early on, I was like, that's hard. Okay, so others?
Hearing impaired?
Yes, hearing impaired. Obviously, you know what it means. You have a difficult time hearing. And of course, there's different levels of this as well. Another real life story. So my school in Ohio, where I was a superintendent, we were in a rural area. We were about an hour and a half away from the most major city, which was Zanesville. Well, a hearing impaired student was identified early on in their life, having total hearing loss, and it was felt that they should go to that special school. They did, until they became a senior. And as a senior, he wanted to play football, and he wanted to be a part of the school. And we made that happen. You know, I'm proud of the fact that we were able to get sign language. We got an interpreter. They did well, and it was a cool experience to watch him be so happy to be where he was, and he wasn't having to ride a bus for about 2 hours a day. So, hearing impaired. Next, this goes right along with hearing impaired.
Intellectual disability?
I couldn't quite catch it. Go ahead.
Intellectual disability?
Okay, intellectual disability. Not sure that the way you define that is one of the, yes, okay. If a person has below average intelligence, yes. And so in Ohio, if a child has an 80 IQ or below, that's when they are considered to be, and I'll use an old term, retarded, okay? This one's a really difficult one because you can't flip a switch and make that change. And the resources that are provided in support groups, support houses, homes, is very, very helpful. Okay. I think we got a couple more. The one I'm surprised you didn't say was
Is it
emotional. I'm
Oh, I
sorry,
was gonna say vision impairment.
physical, yes. Okay. Physical impairment, absolutely. If a person,
Emotionally impaired, emotionally disturbed.
yes, emotional disturbance, you know, and in there they have anxiety disorder, schizophrenia. Wow, bunches of challenging issues there. Think you've got them all, but
I wanted to ask if when the child is labeled cognitively impaired,
okay, you know,
does
cognitive.
that go under a specific one, or because I have a few students in my class that are cognitively impaired, so I don't know what would that be.
Okay, so I would say that you'd probably be looking at intellectual disability. Okay, or you could be, you know, so if the cognitive impairment is around reading, for example, maybe it's SLD. So it kind of depends, and that's where the expert. Oh, and of course, the person who leads the testing is the school psychologist. They lead the testing. Orthopedic impairment, and traumatic brain injury, and multidiscipline are the remaining categories. Okay. Okay. So let's talk about, have any of you, I know it sounds like maybe Angela has been a part of the IEP development by force maybe, but I see her shaking her head.
No, a lot of the kids that I've had to sit in on this year, it was kids that I needed to go down and share my input because it, like I had one kid who was refusing to even come into my classroom.
Yeah,
So, yeah, they need to be.
got to do something. Have to do something. Okay. So the parts of the IEP, and we want you to have just a general idea of this. To start with, you always have to start off with what's the present level, what's their functioning level, and once again, the school psychologist with those multi-factor evaluations is going to determine what that might be. Then we start looking at what are our goals, academic and functional goals. What are we going to accomplish? A general description, the services that are going to be provided, if they're going to be program modifications, what supports will the school provide, if there are any accommodations that are necessary, and the projected date for re-examining the situation. That's what a general IEP looks like. Typically, the special education teacher puts that together, presents it to the multi-factor team and disciplinary team, and with the parent, and gets approval, and off to the races we go. Okay, so have a good understanding, just a general understanding of those parts. There's some other services that we want you to be aware of, and that be related services, assistive technology, transition services, and extended school year services. So let's start with the easiest one, extended school year services.
They're provided to a student with a disability beyond the regular school year in accordance with their IEP.
Yes, if they do not meet their goals, then they must be offered extended school year. Now, what's interesting about this, most kids don't want to go during the summer, and most parents don't want their kid to go during the summer, but you got to offer it. And of course, document that they've refused to participate. So assistive technology, another one that's fairly understandable.
It's a device or software or equipment that helps people improve their functional capability.
Yes, and this field is just going crazy with all of the various devices that can assist. And, you know, I often look at, I see Wounded Warriors, for example, and I see the devices that they at least maintain a decent life with, or it helps them with their life. And I marvel at that. I don't know that you can ever, we can't know exactly what all those devices are unless you're a real expert in that field. But yes, just knowing that that's what that means. The next one is transition services.
I'm not mistaken, isn't this for kind of the stages at the end of your IEP when you're moving out of the school system?
Yes, and actually it starts when you're moving from like elementary school into middle school. You're moving from middle school into high school, and ultimately high school to the world. And that's probably the time it becomes extremely important, is to assist them in making that transition. Related services are all those support services such as speech therapy, counseling, transportation, occupational therapy, that help students with disability succeed academically and socially. Okay? So get into a little bit of the discipline of special education students. And once again, it's changed dramatically, particularly after the Columbine situation and the changes with the renewal of the IDEA. So I'll ask you this question. Can you suspend a special education student? Raise your hand if you think you can suspend a special education student. Well,
Wait a minute.
What's that?
Okay, wait a minute. Like, because like, okay, so I have a student. I mean, I work with a younger bunch. I have a student who is on a modified schedule. They're working on getting him an IEP. He just got an IEP through Troy District, but the family changed their mind now. They want it through DPS. Since he's on a modified schedule, I talked to my teachers. I said, well, we're not going to call for him to get picked up to go home because he's already leaving early through the day, and that's part of our agreement. However, if he does something unsafe or tries to elope, then we're going to call home for him to get picked up because we can't keep him safe, or he may then make somebody else safe. So yes, it depends on what the situation is.
Absolutely. But the general blanket rule is, yes, you may suspend a special education student.
You just can't suspend them for more than 10 days in a school year, right?
Exactly. That's the general
Yeah.
rule. Okay. Now, can you expel a special education student? If a special education student brought a gun to school, remember your situation. And by the way, I had this lesson been earlier on, this would have been a special education student that you would have been dealing with in your case study, your second case study. So if a special education student brings a gun to school, first of all, can you conduct a locker search of that special education student's locker?
Yes.
Yes.
Absolutely, you can. There's nothing that says you can't do that. Okay. The second question is, you discover that, yes, they brought it to school. Yes, but they're special education. Can you expel them?
Yes.
Yes, you can. But
As long as it's not a manifestation of their disability.
yes, and you have to conduct a functional behavior assessment. And if those two things, and once again, I make the claim that I don't know that you could make, I personally don't think you could make a claim that they brought this gun to school and it was because of their disability. I can't fathom that, but I'm sure that the lawyers would disagree. So yes, you can in fact expel. You have to go through those two lengthy processes to make it happen. However, they are going to be placed in an interim alternative placement during that time.
Mm-hmm.
So
have to provide them a free appropriate education and
yes,
address their behavior plan for their goals.
yes. And so that alternative education setting could very well be in their home. And you could be having a tutor go to their home, which would be, I guess, okay. Okay, so we're just about done with this. Explain the differences between the IEP and a Section 504